Um, so if you did not hear me earlier, my name is Eli Pajo. I use he, they pronouns. I'm the resource navigator for the Alliance for Nonprofit Impact. This means if you My role is to connect nonprofits with the resources, people, and information they need to support their staff and mission. A lot of what I do is one-on-one meetings. So if you have some questions about like Alliance benefits or some areas that you need support on, please reach out to me and I'll put my email in the chat. And I would love to schedule time to talk to you. I can do in person, online, whichever you prefer. I like to travel around. But today we're going to be doing HR Compliance 101, what Rhode Island employers need to know, with the Employers Association of the Northeast. And I'm going to turn it over to Mark to introduce himself.
Thank you very much there, and good morning. And I certainly want to thank the team at Alliance for Nonprofit Impact for inviting me to provide an overview of the key compliance subjects that, from my point of view, um, not-for-profits need to be mindful of. And before I get into my formal introduction, and I'm not maybe too formal, I'd like to kind of get a pulse of the audience, and that is to kind of get a sense of what. Oh, let's try this again. Relaunch the poll. There we go. So, want to get a sense of the pulse of the audience. And again, this is anonymous, so this is a judgment-free zone. But if you kind of had to reflect upon you and your role and your kind of history. Um, what's your comfort level in this space, particularly in this space as an HR professional in Rhode Island? Because, Rhode Island is unique in its own ways too. And some, there might be some of you maybe that have migrated from one state to the other, or maybe you're kind of thrown into the HR realm because you're well liked within your organization, thought you would be equipped to handle HR. But so I'd like to kind of get a bit of a pulse check of our group and see, the nature of our audience here this morning before we jump right in. And I see people chiming in. Thank you very much for uh, responding to the poll. Give it another minute or so because I know certainly everyone's time is precious. All right. All right. I'm gonna end the poll and I'm going to share the results. Thank you, Lisa, for your thoughts in the chat too. And I think certainly in a not-for-profit, that's a very good point. I know, sometimes it's a shared responsibility. You're wearing multiple hats when it comes to that. The other thing I would just simply say too is it is a changing process. I know, there are a fair number of you that are new to HR. But the one thing I will say, and thank you very much for taking part in the poll. But the other thing I'm going to say too, even for those that have been in HR for a while, I think someone said they stepped back, stepped away and now they're stepping back in. If there's one thing I will just say at the outset is when we're talking about employment related matters and HR related matters, it's certainly something that I would say is dynamic and is not static. It is constantly changing. And I think sometimes with the pace of change we're dealing with today, particularly, you know, 6 years in the mirror. But nonetheless, I think the pace of change has been something that's here to stay, and we've just got to adjust to it. So, certainly for me, I wanted to kind of give you my state of play on the key things that you should all be cognizant of. So, again, my name is Mark Adams, and I am Director of Compliance with the ANE. And again, I am happy to share with you the key topics that, like I said, whether you're new to HR or been around for quite some time, that I think are the things you need to be aware of to keep on your radar to avoid bringing risk and liability to the organization you serve. We're scheduled to go till 11 o'clock. And over those 2 hours, we'll identify these topics, what those rules and requirements are. And also, I mean, the other piece that I'm really am self-conscious of when I do these type of programs is also wanting to make sure I provide you some of the key practical takeaways that you need to consider in following those requirements to avoid pitfalls when it comes to that. We will take a short 5 minute or so break, roughly halfway through today's program. It may not be exactly at 10 o'clock. We'll see where we are in the content. But certainly, the other thing I will say is along the way, if you have any questions, please put them in the chat, and I will try to address those along the way as the time and opportunity provides too. So I think, and I just want to make sure
Yep.
that the slides are being seen. Are they being seen?
No, we don't
Uh,
see them just yet.
All right.
But while you figure that out, I just wanted to put in a
And
quick amount.
that's not that we've covered anything as of yet, but Sam, feel free to chime in.
Yeah, just one quick thing I want to say before you get started. EA&E is an official partner of the Alliance, so you have access to our HR hotline for free as an Alliance member. So while we want you to put questions in the chat, we want you to interact with today's program. If you feel more comfortable in a private setting, giving our number a call, please feel free to reach out to me. The number is also on the Alliance website. But again, our HR experts are here to be a support system for you.
All right. Thanks for that, Sam. So with that, I will jump in. I wanted to unshare the slides just to make sure you had the proper FaceTime to point all that out. So I want to jump in with, again, I'm going to talk about some federal requirements, and I'm also going to talk about some Rhode Island specific requirements. And because certainly as an HR professional, you need to be cognizant of and be complying with things on both a federal and a state front to make sure you're really putting things in the right position. Now, some of this, I will say, are going to be matters that may have been on the books for quite some time. There are going to be some things that are more emerging that I'm going to address too. And the reason why I kind of am roping all of this in is, again, given that the focal point here is to really get into the basics of what you need to know overall. We certainly don't want to leave things to chance that some of these things have always been on your radar. So, um, and I'm going to start off on the federal side of things, like I said, and that is, in the realm of DEI and interpretation of some of our federal anti-discrimination laws. And as you probably have been made aware, the current administration has made DEI programs an enforcement priority. Certainly was rooted in an executive order that was signed by President Trump on the first days of his administration. So that's been on the docket for quite some time. And then certainly when we're dealing with regulatory matters and you have an administration that puts forth an executive order, that basically tees up agencies then to kind of execute the details of what the principles of that order set out. So when we're talking about this subject, the Equal Employment Opportunity Commission issued its own guidance, and not surprisingly, the thrust of this guidance, as you can see by the poster that has been put out, which is on this slide here, focuses on programs that have the operative effect upon providing favorable treatment to one group at the expense of another. And, when it comes to those programs that provide somewhat of that preferential treatment or exclusivity, the EEOC views those specific types of programs as situations that can be violative of our federal anti-discrimination law, that is Title VII of the Civil Rights Act. Now, the guidance is focused upon raising awareness as well as to provide a pathway for individuals who feel that they have been disenfranchised in a manner for the recourse that they can pursue with the agency. So if you look on the slide here, you might see a little QR code in the lower right-hand corner of this poster. In this day and age of QR codes, it basically operates as a link to directly, um, put people into contact as to how they can address those potential recourses. And like I said, the undercurrents behind this guidance has manifested itself by way of cases that have been put out over the course of time. Those cases collectively with this guidance collectively paints an overarching landscape to ensure that actions overall are more rooted on job related basis, work performance, things of that nature that can be not only established but are followed through on consistently. The guidance, however, is not a directive itself that obligates, per se, employers or agencies. This guidance is there to educate individuals themselves. But because of that, it then has obviously a derivative effect on employers. But subsequent to that, uh, the administration put out a separate executive order that does go to the next level, particularly when it comes to organizations that have federal contracts or subcontracts with the federal government. Now, this particular executive order was enacted in late March. And so, for the most part, it's still relatively in its infancy. Certainly, we would expect more details to come out over the course of the year. But in short, the order requires agencies. So, this is targeted to agencies, not targeted to the public, like what we were talking about just previously. But it requires agencies, to the extent permitted by law, to ensure that their agreements, including subcontracts, include a clause that in effect gets them to affirm for the businesses that they're interacting with that they are not maintaining unlawful DEI programs when it comes to that. So, one of the things then that comes with all of this is okay, does that mean DEI programs are eliminated altogether? And the answer to that question is no. Certainly, to the degree that DEI programs are focused on inclusion, opened up to allow all to participate in, and isn't really slanted towards preferential treatment, those programs are perfectly okay. And one of the things I will say, at EANE, because we get into reviewing the likes of employee handbooks and the like, and some of those do get into discussing programs, is I've seen programs that are, that are called DEI programs, and some of which are simply providing opportunities for all to take part and all to collaborate and all to share with one another, and really foster an environment where it is really focused on inclusion and making sure no one is, kind of shunned out, so to speak. And those are perfectly okay. They're not affected by these two orders and guidance at all. It's really when you're getting into things that really are designed to try to exclude people. Sometimes I see certain affinity programs that might provide specific exclusive access and nothing more as a basis of getting into those. Those are the type of programs that are more within the crosshairs of this current administration. So one of the practical takeaways I would say with all this is you really want to evaluate those programs, and maybe some of you have already done that, to kind of see, are there things that need to be adjusted and fine-tuned with those to just make sure we're not kind of raising an issue. I will say that, we had a wave of inquiries at EANE with some of our not-for-profit members when these requirements were first put out there. Had a handful that were the subject of inquiries. Obviously, I can't name names on that. Uh, I will say that the organizations that tend to get focused on from a federal enforcement point of view are your much larger not-for-profit organizations where there might be feedback coming in of those type of programs when it comes to that. Because some people are like, well, what's the likelihood that we might be called out on it? I will say that, at least based on the feedback we've gotten, it hasn't been the smaller ones that have been the focus of inquiries. But nonetheless, that communication is out there and is something that does provide pathways for people to raise concerns directly with the federal government. I'm now going to pivot away from that subject matter, and I just want to keep an eye to make sure there's nothing in the chat. And we're going to proceed to things that are more in the comp and benefit space related to the one big beautiful bill. So we're going to move away from employee relations for the time being and really get into things that really get into compensation, wage and hour, and benefits. And the one thing I will say when it comes to the one big beautiful bill is first of all, the one big beautiful bill gets into a lot of different subjects, many of which are outside of the realm of HR. And what I really am looking at are the specific things that I think are more should be top of mind for those who are involved in HR and employment related matters, whether for a not-for-profit or otherwise. So when it comes to the one big beautiful bill, one of the centerpieces of it all, from an employer's standpoint, uh, are the federal income tax related provisions to not tax overtime. Under the One Big Beautiful Bill, eligible individuals can claim deductions for qualified overtime for the tax years of 2025 through 2028. Obviously, 2025 tax season is now over, given where we are today, but it is something to be mindful of moving forward. The one thing I will say is you got to be careful not to overreach when it comes to things that may not be subjected to this deduction, particularly when it comes to Rhode Island. And I'm going to kind of refer to some of those things later on in today's program. But when it comes to overtime and what's eligible for deduction, eligible individuals can deduct up to $12,500 if they're filing singly. Joint filers, that's $25,000 for what is considered true qualified compensation. And this specifically refers to what I like to call the half-time portion of what is called time and a half pay under Fair Labor Standards Act. Not to turn this into a wage and hour program per se, but I think hopefully, as many of you know, under FLSA, you got a responsibility for paying time and a half for all hours worked over 40 in a week. So when we're talking about what's subjected to deduction by the individual from their taxes, it's not the straight time for working over 40 hours. It's that additional halftime piece of it, so to speak. And again, what is considered overtime under Fair Labor Standards Act, not premium pay obligations that might arise just based on state law considerations. So one of the things, as hope I'll be touching upon later in general, but in Rhode Island, there are provisions where employers have to pay time and a half if their employees are working on legal holidays. And we'll get into what legal holidays those are later on in today's program, even if they're not working over 40 hours a week at all. So again, for something like that, while you might have an obligation of paying time and a half to comply with state law, let's say hypothetically, if they had to work 4th of July, for instance, since that's coming up next week, that would not be something that an individual could take as a qualifying deduction in the event that they weren't working over 40 hours in that week, for instance, as an example there. For it to truly qualify is overtime that can be subjected to the deduction that is available under the One Big Beautiful Bill. It has to truly be overtime for FLSA purposes. So that type of premium pay for working a holiday in a vacuum would not qualify for that. The other thing I just wanted to make mention of is that the deduction is available to all taxpayers, but based on income, gets phased out over the course of time. For those with modified adjusted gross incomes above $150,000 if they're filing individually, or 300 if they're filing jointly, as I note here on the slide. One of the things as we probably already know, given the timing of the year. Our W-2 was not adjusted for the 2025 tax season to account for these changes under the one big beautiful bill. But I will say that come 2026, when those W-2s come out next January, there that will be accounted for. The W-2 will be updated. We'll certainly keep you posted more on that as details progress. Uh, as employers, first question in the chat. Thank you very much, Rebecca. As employers, what is our responsibility in regards to the overtime deduction? You don't have the responsibility of deducting it per se. What your responsibility is going to lie is making sure those monies and hours are coded properly in your timekeeping or payroll systems. So when it comes high time either to run a W-2, that the earnings that are reflected on the W-2 that gets handed out to your employees next January properly accounts for that. Now, this past tax season, it was more just to keep track of the information so that you could provide employees with reasonable documentation on that to the degree it applied so that they could claim the deduction since it wasn't linked into the W-2 because of the timing of the changes. So it's a little more of a transitional rule for this past year because of the constraints that were there when it came to being able to really not be able to change the W-2 for at all for 2025 tax year. But come 2027, when it comes time to cranking out 2026 W-2 forms, that transition rule is coming off the table. So the thing that I practically suggest is as we're marching through 2026, you really need to make sure those hours are properly coded in your payroll systems. And at the very least, you should be, engaging your payroll vendors, whether it's ADP, whether it's Paychex, whether it's Paycom or somebody else, to see to it whether or not that is or is not an issue, particularly if you have employees working a lot of overtime for you. All right. So, other changes under this law that I wanted to highlight are a couple of, to me, key pieces that I think really are welcome news for employees. For those of you, and I don't know, you can certainly put it in the chat. I don't know how many of you have a Section 125 plan. And if you do, you probably are aware that under one of the aspects under a Section 125 plan is you have what's called dependent care assistant benefits. Where, you have people that can set aside up to $5,000 for their kids if they're in daycare or after school programs, things like that. Certainly, I had the wherewithal of dealing with that with my two kids. And unlike our flexible spending accounts for healthcare, you know, that dependent care program was always capped off at 5,000 for quite some time, despite the never-ending escalating cost of childcare. So one of the things here with the One Big Beautiful Bill, and it really has been a very long time coming, is that is going to be something that is going to be indexed moving forward and be increased upwards as reflected here for tax years that begin after 2025. So we're now getting into a realm, as you can see, where these increases are taking effect. So with respect to that, one of the things you probably are also going to want to take stock of with that from a practical point of view, making sure your plan documents have been updated to reflect those adjustments, making sure your SPDs have been updated to reflect those adjustments. So that can be properly so that your people can properly benefit from those things. And then obviously that then creates a cascading effect as far as what gets withheld when it comes to payroll considerations with all of that. One of the other pieces above and beyond that too is, and it really provides a greater opportunity to really expand what I like to call your total rewards package, is there's a lot of pressure on employers these days to try to help people that they're bringing on board with, student loans, helping pay the tab for student loans. Um, there was a federal law called the Tax Cuts and Jobs Act in 2017 that had provided the wherewithal to be able to exclude from an individual's gross income up to $5,250. Uh, that was earmarked to providing employees the wherewithal to help pay for their student loans. That was a temporary provision, but under the One Big Beautiful Bill, it was now made permanent. And I think part of the reason why that shift happened was the opportunity of employers that take advantage of this, I think was somewhat constrained out of the concerns of it being a temporary provision. In other words, why bother putting in these type of programs, setting expectations, having people try to benefit for it, only to then have their hopes dashed if it was then expired and they had to unwind things thereafter in the future. So with this now being made permanent, I think it is designed to entice more people to incorporate this into their compensation strategy. If you're finding that your people are struggling and wrestling with their student loan programs, just another way to be able to put something else on the table if really you are capped out in what you can put into their base pay, especially for those of you that might be somewhat constrained tying to funding programs that only go so far. It's just another way to innovate how you might be able to provide something. And not that you have to do the full 5250 either. Maybe you can do a lesser amount, but it's just something that you can kind of put on the table that could be attractive to the people you're hiring and retaining. Um,
We
it is
have
something that requires a document to update your documents if you're going to do something like this. And I know there was a question that came into that. Uh, so there is a plan document requirement if you are going to put that into place. And the IRS does have sample plan documents when it comes to tuition and education assistant programs.
and we have two questions really quick. The first one
Okay.
is from Crystal. Does One Big Beautiful Bill make this mandatory for employers
No,
to offer?
no, it's an option. It's just that now that it's made permanent, more employers might want to consider taking up the option, but it's not a mandate
Okay,
when it comes to that.
wonderful. And the next one is from Valerie. What is the mechanism of putting the repayment for student loan program in action?
That's what I just mentioned on plan documents. You got to memorialize it in a plan document and put that out there so people understand who might be eligible to benefit from it, how that's going to work, what the dollar amount is, who's eligible. So along these lines, it's not like you have to make it available to all your employees. You might sit there and say, "Oh, I just want to make it available to my full-time staff, but not my part-time staff." So it's going to come down to putting around a framework as far as eligibility. What is the dollar amount? Again, you can go up to 5250. You don't have to go up to 5250 when it comes to that. Uh, so good questions. So I wanted to get into some immigration matters, and I know for some this is a very much a lightning rod issue, and some organizations have been really struggling with this more than others. And I'd be remiss that to not if I didn't cover this at all, I'd be remiss in terms of overlooking something that to me I think every organization needs to be aware of. Uh, and certainly I don't think it comes across as any shock or revelation that immigration policy has been tightening up in the United States. And there has been a focus on ratcheting up enforcement along the way when it comes to that too. So tightening up on access, tightening up on enforcement, which means that organizations themselves need to have their Form I-9 house in order to, as concerns about employing workers not authorized to work in the United States could conceivably elicit the potential for I-9 audits. And with respect to that, I kind of outlined this workflow of how that plays out in practice here on the screen. And as I mentioned earlier, we will be providing PDF copies of this slide deck to attendees, so no need to be frantically writing all this down. But this kind of gives you an idea of the workflow associated with those type of audits. I can't take credit from this. This is straight from United States Immigration and Citizenship Services website when it comes to that. But one of the things I just really wanted to flag with all of this, is particularly based on what you see here in the on the slide, is the timelines for responding to these type of inquiries is rather quick. Employers often have only 3 business days from receiving a notice of inspection to submit their Form I-9s to the feds for review. Now, they will then in turn audit the forms and check for compliance errors. And as you can see here, depending upon what they can find, they might just simply reach back to you with the notice of technical issues and giving you some time to correct those, and that might just be the end of it. But you only have 10 business days to turn that stuff around. Otherwise, that can then lead to treating it more on a substantive level. And for in those situations, or with things that are viewed as substantive violations altogether, that could ultimately lead to a notice of fine. If the employer wants to challenge the fine, then there's a timeline for seeking a hearing to contest that. That is, they have 30 days from a notice to fine to wanting to be able to pursue that appeal option. If they don't appeal it, then the order is final. If they do seek to appeal it, then whatever comes out of that hearing thereafter would be final itself. So unlike what's called warrants, which we will talk about next, a notice of inspection does not convey the right to immediately seize records from you. You, again, have an opportunity to pull it together and give it to them. But again, it's just 3 business days. So one of the things I say when it comes to I-9s is you really want to make sure you've got your house in order with this. I know one of the things for a lot of people who are new to their organizations, maybe even new to HR, maybe a couple of things we often recommend if you're kind of trying to get a sense of where your strengths and weaknesses are from an organizational point of view, you might want to consider 2 different things. One, an HR audit, just to look at your practices to see if they are all overall on the up and up. But 2, separately, you might want to do an internal review of your I-9 record keeping practices. Are I-9s being completed properly? Are they being retained properly in terms of durations? Are they being stored properly and not commingled with our other personal files where others have the risk of looking at them? Those are things that we often recommend are best practices, just because I know the I-9 has changed over time. There are many different ways you can do an I-9 wrong. We don't have the time to get into all of that here, but because of this enforcement mechanism, you know, that is not the time to be looking at whether or not you've got problems with your I-9 practices. So if there has been changeover in your staff in handling this role, or again, there's been a lot of question about, stepping in new and not knowing what's happened in the past, you might want to very well take a hard look at your I-9 record keeping practices. Now, I-9s are totally separate from what we have seen play out in the news off and on over the course of 2025 and 2026. And that is the issue of, well, what if ICE shows up out of business? We know ICE's enforcement efforts have kind of ramped up over time, granted in different parts of the country and granted at different times itself, and with an effort to try to detain and seek to deport those that are in the United States that they deem have been in the United States illegally. because of this reality, one of the things is we recommend is that you as employers need to have a contingency plan in place in the event that ICE were to visit your facility, let's say wanting to interview or even arrest personnel. And on this point, while ICE can enter public areas of an organization, they cannot enter private areas of your organization without your permission unless they have what's called a judicial warrant. Not an administrative warrant, but a judicial warrant. Now, even if they have such a judicial warrant, to be on your premises, that judicial warrant will define where they can go. So one of the things to be mindful with respect to that is you certainly want to get a copy of the warrant. You want to be able to look at the warrant to really make sure they're not overextending into areas beyond the warrant, and you certainly need to honor those warrants. Now, with respect to that, you might be having the question of, well, what's the difference between an administrative warrant versus a judicial warrant? The key answer is who is issuing it. If it's a judicial warrant, it's being signed off on by a court or a magistrate. If it's an administrative warrant, it's being signed off on by the federal government itself. So that's why inspecting the warrant is important to really know whether or not you can, contest them being on premises or not. If they have an administrative warrant at all, or if they have an administrative warrant alone, you can limit them to the public areas and, certainly turning them away. Maybe they come back with a judicial warrant, for all I know, with respect to that. So companies really have to kind of gauge whether or not they want to make them jump through that additional hoop or not. Different organizations have different points of view on that. The one other thing I will say with judicial warrants is you want to know when they're issued because they have a short shelf life. Judicial warrants that have been issued have to be utilized within 14 days of their issuance, and that is calendar days. So, they can inconceivably therefore expire when it comes to that. So one of the other things to be cognizant of and why it's important to get a copy of the warrant is to see if the warrant's no longer valid. And what that obviously would mean is you're kind of sending them back to sender, so to speak, and probably they're going to come back with an updated warrant when it comes to that. Also, the other thing I would just point out is personnel always have a right to counsel in the event of an arrest. So one of the other things is, to really identify from the ICE agent that might be behind the effort to come on premises, who that person is, identifying where a person might be detained. And the other thing is, you might want to consider being proactive. Do you have a legal resource available on proverbial speed dial so that if you ever are subjected to an ICE enforcement effort, and if you ever had someone that was being detained and you've got a copy of the warrant, you find out who the ICE agent is, and you find out where that person's being detained, that you can certainly pass that information on with regard to whatever immigration counsel you have secured. I don't have a formal recommendation on that in case for those that have that question, so that attorney can then can reach out and provide whatever assistance they can. So you really want to kind of be in a proactive mode when it comes to planning for this than a reactive mode, because I think if you're in a reactive mode, you might miss some key pieces that might limit how your people who, if they are detained, can be properly represented when it comes to that. So hopefully that provides some constructive guidance. And if you don't have counsel, you might want to do some reconnaissance on that as far as securing someone in the event that that were to happen. If an employee changes their name, do I need to update the I-9? That you don't need to do. I will say, however, if in fact they're named, you can do it. There is what's called supplement B of it. The form has changed over time. It used to be section 3 of the form with the older forms. That section 3 now has been broken into two different supplements, A and B. One is to use in the event you have a translator. The other one is to use more for re-verifying documents that are that need to be updated. That usually happens where if you're having an updated document, um, that needs to be presented, maybe because a work authorization document has since expired, let's say, and the person's name changed in the interim. A lot of times that's going to get caught at that step in the process. So can't turn this into a full-blown I-9 program, obviously, but that would be the way of handling that. Where can we find guidance about I-9 handling and storage? Uh, immigrant, United States Citizenship and Immigration Services does have an I-9 handbook for employers on their website that really lays down everything from forms of documentation that can be accepted to record retention durations and approaches for doing that. They also have a separate resource as to how you can remediate and correct mistakes too. So they have some good resources. Strongly suggest you check those things out.
Another question from Lisa from earlier. Do you recommend any particular tools to assist in HR administration? Examples being like Gusto, Paylocity. I'd love something to help me with onboarding.
Uh, I will say that certain payroll platforms have HR modules. I mean, we have an active partnership with ADP. They really have a lot of resources. I will say for some of our members, we also have resources on our website that's obviously membership stuff. Sam can certainly speak to more on that. But I think you really want to vet out if you're not a member of EANE and you're just wondering, does my own vendor have their own or have their own HR modules as a part of the, comp benefit payroll ecosystems that we take part of? I think you have to kind of check that out and shop around when it comes to that. All right. Those were the federal things I wanted to highlight. I want to now shift to things that are Rhode Island specific that you really need to be mindful of. And one of the things I will certainly say as we kind of delve into this is, Rhode Island, like a lot of the other New England states, tends to be more regulated than other parts of the country. And the one other thing I will say is not all the states, even in New England, operate by the identical same ground rules either. So for those of you that might be operating in multiple states, or either because you got fully remote people in other states, you just need to understand Rhode Island's kind of got its own ground rules that you need to be cognizant of there. Um, so we're going to start things off right at the beginning. And that really gets into, well, how are we classifying our people in the first place? I mean, to me, this is one of the ground floor compliance issues that is a huge priority when it comes to state enforcement efforts. And the reason why, and it's a huge priority not only in the state of Rhode Island, but certainly on a federal level, and certainly even with other states across the country. So I certainly don't want to imply it's unique to Rhode Island. And the reasons for that, to me, are obvious. Not classifying someone properly can deprive workers of wages, of benefits. When we're talking about things from the government side of the house, uh, they might be losing out on lost revenue in the form of taxes that are not collected. When it comes to Rhode Island in particular, it also might mean that they're losing out on collecting revenue when it comes to supporting let's say, their unemployment compensation programs, as it were too. So when it comes to, then the question of, well, what do we really need to think about in terms of determining whether or not we're classifying our people properly? one of the things to be mindful of is that Rhode Island does chart a path, that is a little bit different. And that is you kind of have to take stock of the relationship of your people in terms of what they're doing vis-a-vis what your organization's all about. And the one thing I would just throw out here on this point, and I deal with this sometimes with people on our hotline, um, is that some people will say, well, let's just give them a 1099 and then we don't have to worry about all of the different employment related responsibilities that come into play. And that is certainly not the case. I wish it was that simple. Probably your finance people wishes that was that simple. The point I'm trying to make with all of this is while certainly the IRS, Internal Revenue Service, has a huge multi-pronged uh, set of factors that it looks at to determine whether or not the realities of the relationship lean one way or the other between being viewed as an employee or being viewed as an economic or an independent contractor. Rhode Island kind of tightens it up a little bit more. Um, Rhode Island does look at the IRS test for unemployment purposes, but when it comes to like wage and hour, as an example, by contrast, it's a much more stringent set there. And I kind of put those factors up here for your consideration. So, is it conceivable that for purposes of wage and hour, they could be viewed as an employee, but for federal tax purposes, it could arguably go the other way? Yeah, so one of the things you got to really think about, and one of the things we always say for companies is whenever you're dealing with complying with both federal and state, you should always apply the standard that's going to be more generous and protective to your people. And that makes it a lot easier for you to administrate as HR professionals and organizations, um, particularly where you might have laws that on their face are inconsistent when it comes to that. So it is a major priority that can really have a cascading effect when it comes to that. The other thing I wanted to point out that is unique to Rhode Island, this is truly unique to Rhode Island, is Rhode Island has, for workers' compensation purposes, a specific provision that a person is considered an independent contractor. So let's say, for instance, you look at your factors, you look at the relationship, and you're like, you know what? They really are an independent contractor because of what they do, because of the autonomy they have, because what they're doing for us is really kind of outside of what we typically do as an organization. That might all lean to you legitimately viewing them as an independent contractor. But when it comes to workers' comp, at least, there is also an additional hoop or hurdle to jump through. And that is Rhode Island has a workers' comp provision that a person is considered an independent contractor only if they have actually filed a designation of being an independent contractor with the Rhode Island Department of Labor and Training. So, what that means is even if you jump through all these other hoops with all these general factors that I've talked about up to this point, and even if all of that might kind of make you think, hey, they're an independent contractor, you could still own the workers' comp claim if they were, for instance, to get injured working for you or on your property, if there was not that designation on file with the Rhode Island Department of Labor and Training. So, filing the form, places the responsibility on that individual to, in effect, by doing that they have to have their own workers' compensation coverage. But if those hoops aren't jumped through, and if that person were to work for you, and if that person were to get hurt, then you could end up inheriting that claim, even if everything else would kind of lead to them being an independent contractor. So one of the things I would just simply say is if you're going to bring people on board and you're like, well, we really view them as independent contractors, Part of your due diligence should be have they filed that form with the Rhode Island Department of Labor and Training. You just want to make sure you get some affirmation that that is in fact done. And yes, it is only with regard to workers' comp, Rebecca, when it comes to that. So that is a truly unique Rhode Island thing. I'm not aware of any other state that has that additional requirement. But, when we get past this whole question of classifications, now we can pivot into something I think is a lot more fundamental too. And that is the question of payment of wages. When it comes to payment of wages, particularly in comparison to other states across the country, Rhode Island is more stringent in some respects, but also is a little more lax when it comes to others. And you may say, well, what do I mean by that? As a default, the state of Rhode Island requires employers to pay its employees weekly, unless they are granted an exemption from the Rhode Island Department of Labor and Training. And that is different than other states that might provide a little more flexibility when it comes to the frequency of pay. And that catches some organizations by surprise. Now, if you want to seek an exemption, you can submit that application in Rhode Island DLT, and in that process, demonstrate, for good cause, why you need to pay them less frequently. What are you going to be disadvantaged with by, why is it really important, and really try to show that employees are not going to be disadvantaged by paying on that less frequent schedule, like being biweekly. Rhode Island Department of Labor and Training can grant that approval if it finds, you've been in compliance with other requirements. So if you have a checkered past with the Rhode Island Department of Labor and Training on other fronts, don't be shocked if they don't grant the approval. So that is a little more stringent on Rhode Island employers than employers in other states. But on the flip side, when it comes to the like of, well, when do I have to pay people if they leave the organization? Or when do I have to pay people their final paycheck if I terminate them? Rhode Island allows you to pay them on the next scheduled payday, which is a little more lax or forgiving for employers than other states like Massachusetts, where in an involuntary termination in Massachusetts, you actually have to pay them on that day of discharge. So here, like I said, we kind of have a mixed bag. It's a little, it's a little more demanding on organizations when it comes to pay frequency, but it's a little more forgiving when it comes to providing final pay. But it's important that you know where you stand on these things because of the penalty provisions that are under our Rhode Island payment of wages laws. There are civil fines that can be there anywhere from $1,500 to $3,000, let's say per misclassified employee. And there are even criminal provisions too if you're getting into intentional violations as well. And then there's even the ultimate hammer that the Rhode Island Department of Labor and Training can coordinate efforts to revoke business licenses in the state too, if in fact there is a continual failure to pay wages and fines within 30 days of some initial enforcement decision. So there's a whole cascading array of penalties that can come into play. And again, a lot of this is because payment of wages is a major public policy priority when it comes to that.
Couple more questions in the chat.
Mm-hmm.
Is that form required for ICs who reside in another state but work in Rhode Island for you as an IC?
Well, if they're a bona fide independent contractor, then the payment of wage responsibilities wouldn't apply. But again, it kind of comes back to whether or not, again, this is a state by state issue. So, it does raise the question. If you, for instance, are engaging someone to do work for you in the state of Rhode Island, but let's say they are domiciled in, let's say, the state of Connecticut, and let's just say hypothetically they were legitimately an independent contractor in the state of Connecticut, which may or may not be the case, but let's just give the benefit of the doubt that they are. If you are using their services in Rhode Island for your Rhode Island business, and if that doesn't meet the Rhode Island criteria, well, it might still lead to the same consequences. If they are, however, really an independent contractor for Rhode Island purposes, all of this that we're talking about with payment of wages wouldn't apply because payment of wage responsibilities and timelines only pertain to what you do with your employees, not independent contractors.
Mark,
Okay.
if I can jump in, that was my question. It was back from the previous slide. You were talking about how Rhode Island has a specific a form that has to be filed for a designated independent
But
contractor.
that's
And
for
I
workers' comp only. I think the question was payroll purposes. That's different.
No, my question was in terms of for workers' comp. If you have
Mhm.
independent contractors that come in from other states but work for you in the state of Rhode Island, do you still have to file that independent contractor designated form with the state of Rhode Island, even though they're
Well,
not residents?
it's not you filing it, it's them filing it. And my
Correct.
answer to that would be is if they are going to be doing business in Rhode Island as an independent contractor, whether for you or anybody else, they should be filing that. So I would be doing my due diligence if you're going to bring someone in to do work as an independent contractor, is ask them that question. I know you're starting to do work in Rhode Island. Have you met this requirement? If they say no, well, they probably aren't aware of it either. And then I would be sending them the DLT to jump through that hoop before using them.
Thank you.
You're welcome. All right. It
Oh,
is
we
10 o'clock.
we have a couple more questions. But would you like me to ask them now or after the
Well,
break?
why don't you put the questions on the table now, and then we'll take a
Hmm.
short 5-minute break, and then we can pivot into our next topic.
Wonderful. So this was asked at the same time as Valerie's. So I'm assuming it's in regards to the same form. Is this only in regards to workers' comp from
Yes.
Rebecca?
Yes. It's only
Okay.
a workers' comp requirement.
All right. Second one from Valerie. Are salaried employees in Rhode Island required to be paid weekly along with part-time?
It doesn't make a distinction. You can certainly make that. You can certainly, through the application process, try to seek doing a lesser schedule, but the statute itself doesn't make a distinction there.
All right. Final question from Larry. For W-2 employees, if you're a multi-state employer, which state's labor laws prevail? Pay schedule and final pay. Rhode Island or employee's home state?
If if they're doing work in Rhode Island and they're working for you in like if you have someone that's like living in Massachusetts or living in Connecticut and they're coming into Rhode Island and working for you at your Rhode Island location, you've got to comply with you've got to make sure you're complying with the Rhode Island requirements because those statutes don't get into making differentiations in terms of where the person lives. It's just your responsibilities of paying your or complying with those laws with employees that work in the state of Rhode Island itself. Fully remote employees, that's a whole different outcome. And that means you then should be, if they're fully remote, you should be registering in the state where they're providing services exclusively from, and then you would be complying with those requirements, whether it's wage and hour, unemployment, maybe even state paid leave, and the like if it's fully remote.
What about a fully remote employee?
That's what I just responded to, is
Oh,
that you would have to register in the state of that fully
mhm.
remote employee, and then those laws would then apply when it comes to wage and hour, unemployment, paid leave, or other considerations.
Okay, thank you.
You're welcome. All right, I said I've got about 10:03. Why don't we pick back up at 10 after the hour with the remaining part of today's program? So see you at 10 after the hour. 2 minutes until we begin with the remaining part of today's program. All right, it's 10 after the hour. As promised, we got a lot of ground still to cover. And without further ado, we're going to jump right back in and talk about this subject of holiday pay. And I kind of alluded to this a little bit when we were talking about one big beautiful bill and avoiding missteps with overtime under that, because this is not considered overtime for federal wage and hour purposes. But as the state of Rhode Island has an expressed obligation to compensate non-exempt employees at a premium rate of at least time and a half for working certain holidays, which I've noted here. And you can see them all here listed. The question some might say is, well, where's Martin Luther King Day with all of this? That's really for public sector. You know, so when you got organizations working for a city, the state, a municipality, that would also kick in for those, but not in the private sector itself. That's why that is not on this slide. There are certain exceptions to this requirement. I really, from the groups here, I really don't think it's going to apply to many of you when it comes to that. But this is just something to be mindful of very carefully here. In the healthcare, there are some exemptions also for like religious not-for-profits, houses of worship, as an example, licensed security card businesses. But this is something I would really do a deeper dive with Rhode Island DLT on specifically to get more details of the applicability here itself. But the point I just try to make is it's not a categorical exemption for not-for-profits overall. So this is something that is new in 2026 and really is something that's created a lot of angst for Rhode Island employers. It's very controversial. Some people call it a mini handbook requirement, even though that's not what officially the statute says. It does cover all Rhode Island employers, and it requires employers to provide a written notice to be provided to any employee who performs work in Rhode Island at the start of their employment. So one of the questions right out of the chute is, well, what about the employees that I've had on my payroll prior to January 1, 2026? There is nothing that's been stated that means you got to go back retroactive and give it to them. But for people that you're hiring on or after 1/1 of this year, this does apply. And this is not just the beginning and ending of it on this slide. I'm going to follow through when it comes to that. But you're to provide a written notice to employees on the likes of the rate and pay and basis of their pay for the position they're being hired for. Are they being paid hourly? Are they being paid salary? What is the shift they're working on? Is it first shift? Is it an overnight shift? Is it a weekend shift? When it comes to that. Uh, are there any allowances being provided for meals or lodging? Some not-for-profits get into that, others don't. Maybe that's not relevant. If it's not relevant, then maybe that's just an NA just to declare that there isn't such a thing. Uh, what are they eligible for vacation, sick, or personal benefits? Not that you have to put the entire policy on the notice per se, but you need to at least identify whether they're going to be eligible for participating in those programs.
Uh,
Potential deductions from their pay. Is there a question?
yes, so we have two questions. First one from Rebecca. I asked DLT about holiday pay. I asked DLT once if I could flex holidays, i.e., can we work the 4th of July and take off Good Friday? They told me yes. What do you think?
I would say get that in writing.
Hmm.
Uh, that's all I can really say on that because there's nothing in the statute that per se automatically does that.
Hmm.
And if you've ever taken one of our documentation programs, one of the things we always say is if it's not documented, it didn't happen.
Hmm.
I know that seems like a practical thing, but in this day and age of dealing with people coming in and out, I would get something in writing, get an opinion letter, get an email confirmation, tuck it away so that you can lean back on that. That would be my 2 cents worth there.
Second question from Crystal. If our employee handbook has all of this information already and they sign the documents before starting work, do we still need to create this additional notice?
The answer is yes. Uh, there is, I've talked to a lot of Rhode Island law firms out here. The way that this is constructed is to provide special attention to these key subjects. And those subjects even go on to this page too. And not to have it spread out and dispersed maybe through some sort of a 40 or 50-page handbook amidst a lot of other things that may not be covered under these specific categories. So, yes, your handbook is not going to per se address it based on how the statute is currently written. It talks about a written notice. There is nothing that talks about a company's handbook being used to satisfy the requirement. So, unless and until there is some either modification of the statute or DLT coming out with an official position or guidance that would say to the contrary that you could do that, I would say that that's not going to replace your requirement when it comes to that. So, and in terms of the notice, the one thing I will simply say on this, uh, Rhode Island does not have a template, so to speak. I will say the other state that comes to mind that does something like this is the state of California, but unfortunately, their combination of things is not the same as Rhode Island. They have come out with a model template for their specific state law purposes. Rhode Island hasn't. So I think it's really, hitting up your categories and really just having a blank form that allows you to populate your positions because what one organization might do on these topics might be different than another organization. So it's not like all the narrative for these sections is canned because as we know, you might have different, not everyone has a vacation and sick policy. Another organization might have what's called a paid time off program. Not everyone necessarily is going to like have the same pay schedule, same working schedule, same deductions. Obviously, here, as you can see, contact information is going to be different. So again, unfortunately, completing the notice might look different from company to company, and completing the notice might look a little bit different within employees you hire within your company because you might hire a part-timer, they may not be eligible for your vacation. You might hire a full-timer and they might be eligible for your vacation. So the content of it might even look different internally when it comes to that. Can an email be a written notice? I think you better make sure you retain that email, be able to confirm they received it, and be able to regenerate it. There's nothing in the statute that expressly gets into that, but I would almost apply an I-9 kind of approach there. You got to be able to pull it up, be able to regenerate it in written form if push comes to shove. And again, with emails, you just run the risk if it never got received, are you going to be able to confirm that you provided it to them? I think those are practical issues in wrestling with that topic. All right, pay equity. Unlike other states like Mass and Connecticut that have pay equity laws that prohibit employers from paying men and women differently, Rhode Island goes even farther and prohibits Rhode Island employers from paying employees of different protected classes who perform comparable work differently as well. So it reaches out well beyond just concerns about paying men and women differently and gets into the categories I've alluded to here. Now, what is comparable work? It is not exclusively based on a singular job or job title alone. Comparable work means looking at positions that are comparable in light of their skills, their effort, their responsibilities, and working conditions. Now, there are areas where you can be justified in paying people differently for comparable work among different groups. And I note a lot of these here. So obviously it's making sure that you kind of have documentation and a framework in place. So if you really are going to treat people who have been with you longer than others differently and you got a bona fide seniority program, great. Merit systems, well, what does your performance management protocols look like? And are you really able to tie what you're doing in terms of, giving people adjustments because they're high performers versus low performers? Uh, Measuring earnings and quality of production, that's more for manufacturers than not for profit. So I really don't see that. Geographic limitations. Now, before you all say, okay, well, that gives us the justification to pay people in Providence higher than maybe pay people in a more rural setting in the state of Rhode Island, under the Rhode Island pay equity law, you're not permitted to pay people differently on the basis of a geographic if they're all working in the state of Rhode Island. That's not going to apply. But if you had workers that were actually, let's say, fully remote, working across the border in Massachusetts or Connecticut, that might be permissible if their cost of living in that other locale truly was different than the cost of living where your organization is based. So I'm not even going to necessarily say that's automatically viable. You're going to have to look in that much more intently when it comes to that. And then when it comes to that, then, practically speaking, you kind of want to document, what's justifying you being able to pay people differently as far as those permissible differences. And then the other thing I would just simply say is you don't want to just set it and forget it. As we know, jobs change over time, particularly in a not-for-profit space, as you're getting more constrained and having to innovate based on changing financial and operational resources. Maybe you're structuring jobs differently, consolidating positions differently, consolidating programs differently. What's the consequences of that in terms of how you're compensating people? Are things comparable now, but as you're doing all of that, things get out of kilter down the road? And do we have to revisit that before we just fully implement those adjustments and realize we're running into a pay inequity issue as the consequence of that? So it's just part of your, what I'll call your due diligence as you're evaluating how to operate as not-for-profits, to not lose sight of this in the calculus of things. Now, I am going to talk about this affirmative defense, but I really would just point out that this is going away. The statute does build in an affirmative defense wherewithal, such that if you do a proactive evaluation, you see that there's problems, you go to fix those problems, that you can be shielded from liability under the state pay equity law for state pay equity violations. Unfortunately, that defense is coming off the table at the end of this month. So unless you're going to scramble and do things in the next 3 or 4 days, technically this isn't going to really be a viable path for you. That doesn't mean you disregard fixing things. It just means that you're not going to have an affirmative defense to be able to benefit from if litigation were to ensue. The other thing I would just point out with the affirmative defense, regardless, is the affirmative defense would not shield an employer from liability under, let's say, federal law, like the Federal Equal Pay Act, if there was a concern about paying men and women differently. It's only a defense in shielding from state pay equity violations. But like I said, a lot of this here is pretty much not going to be a viable option for those of you on the line today, but I technically needed to share it given when we're conducting this webinar this morning. Now, I guess I'd ask a semi-sarcastic question. How many of you really like to manage leaves within your organizations? If you do, put it in the chat. But for those of you who have had the experience of managing leaves in accordance with the Federal Family and Medical Leave Act, you probably already know that in the state of Rhode Island, we have a state FMLA leave law, which is not identical to the federal standard. While, eligibility is somewhat similar, the employee eligibility thresholds are a little bit different. Federal FMLA employees that work for you, if you have 50 or more employees, have the wherewithal to go out if they've worked 12 months and 1,250 hours. You can see here the Rhode Island employee threshold is a little bit differently there. The durations are different. Federal is 12 weeks in a 12-month period. State of Rhode Island is 13 work weeks in a 2-year period. Now, you may sit there and say, why are we belaboring this? Why are we even getting into things like reasons being different? Family relationships being different, as you can see here. Under federal FMLA, you can go out for parent, spouse, child. That's it. Who have serious health conditions. Rhode Island, as you can see here, it's parent, spouse, child, but then you get into in-laws and domestic partners. That's not covered under federal FMLA. And the reason why I kind of point out these distinctions is you've got to be mindful that while there might be many instances where federal and state leave can run concurrently for administration and tracking purposes, there might be instances where they can't. So a pitfall that I find some Rhode Island employers can fall prey to, and I would point out here, is if there is a situation that would fall under Rhode Island, but not federal FMLA, you can't count that towards their federal FMLA allotment. So if they're going out for a domestic partner who's got a serious health condition and legitimately can go out under Rhode Island Parental and Family and Medical Leave, that's not going to count towards their 12 weeks under federal law because it's not a qualifying reason, not a qualifying family member relationship. And what that could therefore mean conceivably is they might end up having time available later on under federal FMLA that they can then use later on for something that truly is covered under federal. So you really need to understand that those distinctions, because if they later come back to you wanting a bona fide federal leave request and you, for instance, deny it, thinking they don't have any more time available under the assumption that the Rhode Island situation maybe that they had before burned in effect the time they had under federal, that could be a potential risk of an interference under, an interference or retaliation claim under federal FMLA. That could put your organization at risk. There's a question about being under 50 employees and, we allow a personal leave. That's perfectly okay to do. The one thing I would just simply say, if you're going to do that as a matter of practice, just make sure in that policy, in your handbook or otherwise that you communicate for you being under 50, that you're not saying you're complying with family and medical leave or you're complying with the Rhode Island Parental and Family and Medical Leave. Don't hold yourself out to being subjected to that law or laws.
Oh God, what is
Because,
this?
yes, their question? Okay, maybe it was just a mic issue. Don't hold yourself out if you're not subjected to those laws because you could be held accountable to it if you screw it up. That would be what I would say. So, you want to do a personal leave, you want to kind of framing out like FMLA, fine. Just don't put yourself out that you are subjected to or complying with those laws if those laws don't apply to you, which in your case, Lisa, you're under 50 employees, so you wouldn't be subjected to that. Excellent question. Independent of our leave laws, which basically provide time off protections on a federal and state level, Rhode Island is one of the first states in the country. Matter of fact, it's the oldest program in the country that provides some sort of a wage replacement mechanism for certain leaves. And I'm going to start off with temporary disability insurance, otherwise known as TDI. TDI provides wage replacement benefits to covered employees who are temporarily unable to work due to a non-work-related illness or injury or pregnancy. It is one of the oldest programs, like I said, in the country when it comes to this. One of the things that I would point out with respect to this is they can go out for up to 30 weeks. That does not mean all of that is job protected. The only way the job protections are going to come into play while someone's out on TDI is if, in fact, there's another law that might run concurrently that in and of itself might provide for protections, like federal FMLA, like Rhode Island Parental and Family Leave. If that is the case, then now time off would be protected because of those other laws that would run concurrently. But the TDI does not provide for all 30 weeks to be protected. Let me just be abundantly clear when it comes to that. One of the other things I will say with TDI is people could conceivably go out or take TDI partially and work for you partially. That can be a viable path there, and that's different than TCI, which I'll talk about in a minute when it comes to that. The other thing I will point out while someone's out getting TDI benefits, TDI benefits does not make someone financially whole. An employee can top off their TDI with the use of PTO as well. That is different than TCI, or what's called temporary caregiver insurance. And it's different on a lot of levels. Unlike TDI, that's for someone who themselves has an illness or injury that's non-work related. TCI is there to care for a family member who is ill, for instance, like a child, like a spouse, like a domestic partner, even in getting into the likes of grandparents. So that's a little bit different than FMLA. It also gets into the bonding situations, the birth and bonding situations, the adoptive situations, the foster care situations that they could go out there too. Now, when it comes to TCI, though, the amount of TCI that you get is different. But the important thing I really wanted to emphasize is unlike TDI, which is not job protected per se, TCI is. So even if they're not eligible for FMLA, even if they're not eligible for Rhode Island Parental Family Medical Leave, even if you are like Lisa working for an organization that has under 50 employees and therefore those two other laws don't apply to you at all, you got someone that goes out on TCI, that time off is job protected. And one of the other things I would point out, and I note this on the slide, the amount of TCI benefits and time off that they can get has changed over time. It used to be at its inception, I think it was like 4 weeks, and it's gradually started to work its way up. This year, it's up to 8 weeks. So one of the things sometimes I see when I look at Rhode Island handbooks that have put out a statement on TCI, and there isn't per se a requirement that you have to do that in your handbooks, but some do. Just don't misrepresent the benefit duration here. The current state of play is 8 weeks when it comes to that. Uh, but there are also additional reasons that are now online when it comes to being able to go out on TCI, when it comes to organ donation, bone marrow donation. Those were things that weren't the case prior to 2026. So I just wanted to kind of put those on the scene for you. From a whether it's TDI or TCI, there isn't a you're not administrating those, you're not approving or denying those claims, as the case might be. That's really something that the state is going to handle with respect to that. I got a couple of questions in the chat. Does TCI have to be concurrent? Again, that's going to somewhat depend upon the overlap timing wise between how your FMLA or Rhode Island parental leave policies are structured vis-a-vis when the TCI claim is with respect to that. It may not always happen that way. The other thing I was going to mention with TCI that I didn't mention earlier, unlike TDI, like I said, where you can work part-time, so you in essence could collect partial TDI benefits. With TCI, that's not a viable option. Those weeks have to be continuous there. So that's another thing to be mindful of when it comes to that. Another question, if someone is eligible for FMLA and also TCI, can you count the time concurrently? Again, it comes back to how your policy is structured as to whether or not it is going to fully overlap or not knowing your 12-month period under your FMLA policy, because that can be done differently. Do employers receive documentation from DLT that an employee is on TCI, or do we have to request the doc? You can ask that from the employee if you want to. But again, you're not going to have any priority in the adjudication, challenge, or appeal process of that. That's going to be between the state and the employee / claimant. All right. Sick leave. When it comes to, paid time off benefits itself, there isn't any requirement like in Rhode Island to have to provide the likes of vacation time itself. But Rhode Island does have a sick and safe leave law that applies basically to all employers. The question really becomes, does that have to be paid sick leave or unpaid sick leave? And the magic number there is whether or not you got 18 or more employees. If the answer to that question is yes, it has to be paid. If you're below that threshold, it can be unpaid, but you do have to provide the time, and it is protected nonetheless. Yes, when it comes to how you count the 18, there is no full-time equivalent calculation behind that. Part-time employees count the same as full-time in terms of counting heads for purposes of whether or not you've met the 18 employee threshold when it comes to that. One of the other things I will say when it comes to this too is, again, state law sets a minimum standard when it comes to this. The minimum standard is an ability of being able to earn time at a minimum of 1 hour for every 35 hours worked, up to 40 in a year. You could do something more generous than that, and that is you could do what's called front loading the time, where you just say at the beginning of a year, here's your 40 hours that you can take. That's perfectly okay to do when it comes to that. The one thing I will say, uh, if you are going to do an accrual-based approach, you need to have a rollover provision that allows people to roll over up to 40 hours from one year to the next. For those of you that provide front-loaded sick leave, you don't have to do rollovers. The one thing I will also point out that sometimes I get the question on, particularly with not-for-profits, who might say, hey, I've got full-time people and part-time people. Could I front load the benefit for full-time people and just accrue it for part-time people? And the answer to that question is yes, you can, but you just got to make sure your policy is clear on those distinctions, and you've got to make sure, therefore, for those that are doing it on an accrual, that you have a rollover provision for that subset when it comes to that. Again, the time off is job protected. You have limitations in terms of asking for medical documentation. Can't ask for a doctor's note unless they've been out more than 3 days itself. I'm seeing some questions pop into the chat. We talked about the TCI pieces. Okay, here. Can you clarify about waiting periods on paying out paid sick leave on request for use? I'm not quite sure what you mean by that, so to speak. There is a waiting period when it comes to being able to use sick time uh, with respect to 90 days. So the problem is once you get past 90 days, they get to use the sick time that they would have earned throughout the 90-day period when it comes to that. So there is a 90-day waiting period with respect to that. Can you use PTO to comply? Yes, if your PTO policy meets all of the requirements. So with respect to that, if you only offer part PTO to your full-time employees, you better have some other sick policy on the books to cover your part-timers if you got part-timers. But you can use a PTO. Is there a minimum amount of rollover to be allowed? The sick leave law allows people to roll over up to 40 hours of unused time from one year to the next. So it's not so much a minimum, it's more that they have the right to roll over a maximum. That's the minimum standard. You want to allow people to roll over everything, you could. You don't have to do that when it comes to that. All right. Okay. In terms of covered reasons with respect to that, there are a variety of covered reasons that can be used under this Rhode Island Sick and Safe Leave law. I've provided some of those here. Again, you're going to get these in your slides as well. This has changed over time from the law's original inception. And I note that in particular here, like when you look at this particular reason here, what quickly comes to mind is scenarios that we had confronted during the pandemic. When you're talking about facilities being closed due to public health emergencies, the employee or their family members perhaps being quarantined due to concerns that would allow them, that would maybe cause them to jeopardize the health and safety of others. Those are reasons there. So the only thing I would say with respect to this is you really just want to make sure you are auditing and reviewing your own policies. I get some people that will say, oh, well, we offer a lot more than 40 hours, so we should be in the clear. Well, again, who's eligible for it? Rhode Island Sick and Safe Leave, everybody has a right to earn time. And to the degree that they've earned it, to the degree that they're no longer in a waiting period, that they can take that time with job protections. How much time you give is just one piece of compliance. Who gets to earn it? Can they use it for all the covered reasons? Are we setting up burdensome notice requirements that go above and beyond what the sick leave law requires? Are you allowing people to roll it over with accruals? Are you requiring documentation in ways that are more stringent than what the state law requires? You really need to vet out your policies on a number of different levels when it comes to this sort of thing. So, that would be one of the other things I would really allude to um, when it comes to Rhode Island sick leave. Um, as far as other laws, I wanted to kind of make you aware of, there are other leave considerations out there, but one that doesn't arise very often is military leave. Federally, we have a statute called the Uniformed Services Employment Reemployment Rights Act, otherwise known as USERRA, that allows for an employee who's going out due to their own military service to go out for up to 5 cumulative years. But Rhode Island actually has its own separate law. As I note here, the Rhode Island Military Family Leave Act, which is there for employees whose spouse or child is called to military service. And the amount of time off that is available is based upon company size. I kind of see this, I kind of note that here. This is also relevant, particularly for those of you who are smaller not-for-profits. As we mentioned earlier, federal family and medical leave applies to companies with 50 or more employees. Federal family and medical leave does have some reasons that kind of coincide with the Rhode Island state law. So for those with 50 or more employees, it very well could be that this state law is going to run concurrent with federal. But for those of you who are under 50, for those of you who therefore are not subjected to federal FMLA, but you have a situation with one of your staff that is looking to go out because of needs that are tied to a family member getting deployed at military service, guess what? This state law is going to come into play. Granted, it's only going to be for 15 days for those of you below 50 employees, but it is something to be mindful of. I would say on the flip side, for those that are subjected to both federal FMLA in this law, where I really see this coming into play more directly would be you got an employee. They took all 12 weeks of leave, maybe to take care of a child with a serious health condition. And then lo and behold, after that, in the same year, family member gets called to active military. You may not have any FMLA recourse anymore, but maybe this still comes into play. So timing is everything in the realm of leave management administration when it comes to that. There is also separate for those that are over 50 employees, the wherewithal of Tappan Rhode Island parental and family and medical leave for school activity purposes, as I note here. You can kind of see that it's a subset. They don't get to use the full amount of time. It is limited. It's capped out at a handful of hours, as I note here. You could certainly be more generous as a matter of policy. But again, I just bring all these out as a call to action for you to inventory and review your own freestanding policies to make sure you're not missing anything when it comes to this.
We have another question in the
Yeah,
chat.
I just saw it pop in.
Mhm.
If you,
Stacy says, if you front load a sick time, could you do it on a 6-month basis, like on January 1st and again on July 1st, allotting time for the next
I
6-month
would
period?
check with DLT on that. There are constraints with front loading and less than annual basis on that. I'm not familiar as to whether or not that would be permissible, but DLT does have FAQs on that, but I would be very leery of that. But it's a good question. So again, it's just the takeaway of all this is just making sure you really know when and how to run your leaves concurrently. And, who knows? If we do this compliance program in a couple of years down the road, who knows? There might be another leave law coming on the books. Time will tell. But there are other things that kind of lay in the weeds independent of our freestanding leave laws. And one of those gets into how we reasonably accommodate workers. And certainly, while reasonable accommodation is nothing new to HR professionals, um, because a lot of times we run into that with disabled workers in general, maybe under the Americans with Disabilities Act on a federal level, or even just under the applications of our state Fair Employment Practices law that similarly provides reasonable accommodation obligations on Rhode Island employers. Um, we also independently have responsibilities to accommodate pregnant workers. And in Rhode Island, we have to inform our workers of their rights of accommodations of this, not only at the commencement of employment, but also within 10 days of a worker becoming pregnant, if they make you aware that they are pregnant. And with respect to that, one of the things that I always tell Rhode Island employers is this is an area that to me, you also need to make your managers aware of because, if any member of management is notified, that kind of puts the company on the clock to reconfirm that notice. You got 10 days to do so. So you don't want to be delinquent in giving the notice properly because maybe the employee's frontline manager or department manager knew about it, but never clued you in to follow up and do your notice responsibilities. That's similar to other states like Massachusetts that have done this. And the reason why there's this re-communication requirement is they don't want to have people get the notice and then maybe, who knows, 4 or 5 years down the road, they get pregnant, they've lost track of what their rights were. So it really kind of puts that notice in front of them, conceivably at the time of need, so to speak, when it comes to that. So this requirement is something that many states have picked up and have done, and you just don't work that into your own processes to make sure you are reaching back out and understand the expectations of what accommodations might look like in practice. Some of these might have more of an impact on you than others when it comes to that. A lot of it kind of overlaps with federal law too. But what is unique, and this came into play last year, so Rhode Island is the first state in the nation to require employers to provide reasonable accommodations for workers suffering from the effects of menopause and related conditions such as hot flashes and night sweats. The new obligation was achieved by basically, if you look at the statute, by incorporating the terms within the original framework of the pregnancy accommodation law that I just mentioned. So basically what that means is for those of you who are covered employers, and it's probably just about everybody on the line today, given the low threshold, as I note here on the slide, you better make sure you're updating your policies and your notices to kind of expand out to not just talk about pregnancy accommodations, but pregnancy and menopause, so to speak. We've gotten a handful of calls at EA&E on, well, what would an accommodation look like when it comes to this? It might be things like flexing out your dress code policy a little bit more, maybe allowing people to bring in a fan to circulate air if they're dealing with an uncomfortable workspace when it comes to that. I'm not saying you have to change up all your HVAC and climate control systems. That's probably going to be more of a hardship. But, maybe it's going to be things that are just designed to make people feel a little more comfortable in the workplace. That's kind of the situations that we've encountered on the hotline when it comes to that. This law did create a responsibility for companies to provide written notice of these expanded rights to existing employees. Obviously, you've got to provide notice to your new hires at time of hire and, again, as needed when they tell you they've got this condition. But for your existing employees, there was a responsibility for you to have notified your existing employees within 120 days of the law's effective date. That was back in late October last year. Suffice it to say, given that we're sitting in here in June, that should have been done by now, when it comes to that. So if you haven't done that, obviously you want to make sure you get that out the door and make sure they are keenly aware of that, when it comes to that notification. But Rhode Island is the first state to require this. And the last thing, do employees have to provide medical proof of menopause? It was in the chat. The law is kind of silent on that piece of it. So I would kind of I mean, even if there's no medical proof of it, there's nothing that inhibits you from having a conversation over what's going on. And I really haven't seen with any of the questions we've had, companies trying to make people jump through those hoops when it comes to that. And part of the reason why, and it kind of comes back to our pregnancy discrimination or pregnancy accommodation laws, is you got limitations on when you could get documentation for in short, when you're dealing with accommodations that would be things that would rarely encounter an undue hardship, there isn't really a permissible ability of seeking out documentation in those circumstances. I think flexing out a dress code policy or allowing someone to bring in a fan, I don't know where that's going to really steer into hardship issues realistically. So I would really steer clear of that. Usually, when you're getting into documentation, it's where the accommodation in question would truly have undue financial or operational hardship challenges for a business. That's when that typically has been a viable path. I don't really see for menopause situations that being the case. And the final thing I wanted to talk about as we're getting to the top of the hour is a topic that's been on the scene for quite some time, and that is this subject of sexual harassment. And this is also a state by state topic. And I like looking at Connecticut to the west as an example of this. Like Connecticut, for instance, Connecticut has an actual training requirement that they got to train. You got to train everyone in Connecticut, for Connecticut employers, they got to train everybody on sexual harassment. Rhode Island doesn't do that, but Rhode Island does require that you have to have a policy in place, and you got to distribute that policy to your employees at time of hire. And that policy has to have certain type of elements, and I kind of note those all here. So for me, the practical takeaway from this is review your policies, make sure you're not missing things. For me, where I see things getting missed a lot of times is maybe we're not pointing out that people have a right to be free from retaliation. We're not really talking about all of the legal framework the way we should. Maybe we talked about what sexual harassment is, but maybe we have glossed over providing examples. And I would say best practice on providing examples is tailor the examples maybe to the nature of your business so they have a better understanding of how those things can happen in practice with your business in mind. So for instance, one of the things a lot of times I'm adding in is examples to a company policy, particularly if I see through other policies or engage or other practices with a company. If your employees have a habit of maybe using the internet or social media or text messaging as a way of communicating with others, are you kind of talking about some of those being potential instances of harassment if the use of those mediums or channels elicited, sexual uh, imagery that could be uncomfortable or unwelcome to a recipient, as an example. But in any event, you just want to make sure you're auditing your policies. So those were the topics I wanted to talk about here today. We jumped through a lot of different hoops on a lot of different subjects, and we got just a couple of minutes. I don't know if we have any other questions out there. I don't see any. Any other final thoughts? I'm just also trying to look here. Oh, I did see one way back as I frantically scroll back and forth. Someone asked the question of, well, can you cash out unused sick time in lieu of a rollover? Yeah, actually, technically you can, if you want to allow for that. But the problem is you got to also front load then time. And that's why some people we find typically don't do that. So, Rhode Island sick regs get into that a little more, but it's conceivable. But we find most people don't do that, so to speak. All right. Um, I thank you all for allowing me to spend the last couple hours with you this morning to kind of talk about this. As Sam alluded to earlier, we do have a hotline service that's available through our partnership with the Alliance for Nonprofit Impact. If you do have questions, don't hesitate to take advantage of our hotline. It's there to serve you. Sam, I didn't know if you had any other final thoughts.
No, absolutely. I'm going to put in the number one more time, but the hotline is open Monday through Friday, 8 a.m. to 5 p.m. Please just mention that you're calling as a member of the Alliance so our hotline team knows that you have free access to this service. But our team is here. They're local experts. They understand what's going on in your area. So even if it's not just a compliance question and you need someone to just be a thought partner with you, if you think you're doing it the right way, but you just want someone to, check things over with you, it's a great resource for that as well. Um, we're also here again if there's anything that's more significant that you have a project that you need help with. Alliance members do get preferred pricing on some of that more consultative support services as well. So please feel free to reach out to myself, anyone on the Alliance team, Mark. We're here to help you with all your HR needs and just know we're in your corner. And thank you for your time today.
Enjoy the rest of your day and weekend, everybody.